Hi, I'm Christopher, owner and founder of Brine Consumer Law here in Worcester, Massachusetts, where I exclusively help people find solutions to unaffordable debt and debt-related problems. Today we're going to be going through one of the most frequently asked questions that I get here at my office, which is, what is a debt buyer? And if you're struggling with unaffordable debt that's past due, odds are you're being contacted by a number of different companies who are trying to collect that debt. If you don't recognize the name of one of those companies, if you've never heard of one of those companies, then odds are that they're either what's called a debt collector or a debt buyer. And debt collectors is really just a company that's trying to collect the debt on behalf of somebody else. They're typically hired by a creditor specifically for the purpose of trying to collect a past due account, and any payment that you make to the debt collector would go back to the original creditor. So for example, if you're past due on an old American Express account, you might get contacted by a debt collector who's been hired by American Express to try to collect the debt. That debt collector doesn't own the account, and any payment that you make to the debt collector goes back to American Express. The opposite of that is what's called a debt buyer. Debt buyers are companies that purchase past due accounts specifically for the purpose of trying to collect it for themselves. They'll typically buy past due accounts from original creditors in bulk, typically by the thousands, and usually for very small amounts, usually pennies on the dollar. Their business plan is to turn a profit by then turning around and collecting the full balance owed by you. Now, some of the most common debt buyers that I see in my practice are Midland Funding, LVNV Funding, Cavalry, Cash or CACH, and Portfolio Recovery Associates, among others. Now, both debt collectors and debt buyers do engage in similar business activities. They both make debt collection phone calls, they'll send debt collection letters, and as a result, both are subject to state and federal laws about debt collection. The difference, though, is mostly important if and when a debt collection lawsuit is filed against you. If you're sued, you'll either be sued by the original creditor or by a debt buyer. Like I said, debt collectors don't own the account. If you're sued by a debt buyer, then the debt buyer typically will have specific evidentiary issues or hurdles that they'll have to overcome in the case. So, for example, let's say you're sued on an old Bank of America account. That account has been assigned or sold to multiple debt buyers on different occasions, and you're now being sued by some debt buyer company that you've never heard of. Even if you don't dispute the Bank of America account, even if you agree that that account is yours, that the amount that they're suing is right, the debt buyer that's suing you still has to prove that they're entitled to sue you. They have to prove what's called a chain of title, proving that they're the current holder of the account. It's similar to a chain of title issue that you might see in a mortgage foreclosure context regarding proof of assignments on a mortgage. In Massachusetts, the case law is clear that a debt buyer is the entity that has the burden of proof to show that they're entitled to sue you. It's not your job to prove the opposite. And the chain of title must also be proven with admissible evidence. And the rules of evidence are governed by the court's general rules of evidence. So particularly when it comes to district court and superior court, the rules of evidence might pose a difficult burden for debt buyers. Small claims court, as you might see elsewhere on my website, small claims has a much more lenient rules of evidence that might be more favorable to debt buyer arguments or documents. If your account has been sued or assigned multiple times, then the debt buyer also has to prove each and every one of those assignments. They have to prove that your account was included in an assignment, and they have to prove each and every one of those assignments with, again, admissible evidence. So that can pose an even further burden on the debt buyers that can be difficult to show in many circumstances. So as a result, if you're being sued by a debt buyer, particularly a debt buyer that's been a third, fourth, fifth generation assignee, which is not uncommon, I would strongly encourage you to review all your options with an attorney because you might have more than you think.